Mr. Stanley, how are you? We're ready to start. We just got ready to start. So the state has rested, and it is at long last time for me to shift this way a little bit and look at the defense and say, what are we doing next? Do you have a motion?
Motion for directed verdict on counts 1 through 7.
Okay.
Harvey's arguing 1 through 4, and Lisa's going to respond to that. I'm going to argue 5 through 7. If you want to, which I gather is not now.
Correct.
We have, I think on 1 through 4, I think the point was we were just going to rest on the motion and not argue it.
Okay.
At this point, we may argue it, close the defense case or close the rebuttal case under the standard of, whether a reasonable jury can reach a verdict guilty on any one of the first 4 counts.
Okay.
But we will re-argue it at the time to close the defense case and at the close of whatever the rebuttal case. We do want to argue 5 through 7 at some length, as you can tell from our pleading. If we're doing that this afternoon, after we put up a defense witness, that's fine. We do have, I noticed, I was outside, we have 2. I was a little unclear, I was talking to them, but I know we're calling 1 who traveled from the other side of the state.
You call whoever you want when we get started, but before that, we need to talk about these things. So I'm hearing that Mr. Hardy may very perfunctorily say we move for a directed verdict.
I just did.
Okay, you did it. All right.
That's how perfunctory it was.
Counts 1 through 4.
That doesn't mean it wasn't serious, but it's
No.
we understand the standard under which you will be operating.
Okay.
For purposes today, we don't have anything more to argue with counts 1 through 4.
Then the record that's before us all.
Right.
Okay. All right. And then 5 through 7, it's a timely made motion for directed verdict. We'll talk about it 5-ish today.
Yeah, I was asking about that. So you want us to go until 5 with witnesses and then start the arguments? Just that
Yes.
I have other commitments to 6, but that's fine. We've got witnesses and I also teach tonight. I can be there at 6.
Okay.
Just George State.
Okay. I think we can accomplish that.
That's great.
The conversation with Mr. McIver about testifying. Defer to that?
We got plenty of time tomorrow or
Okay.
and Thursday.
Great.
To address that.
Anything from the state?
Your Honor, as to counts 1 through 4, the state would just contend that obviously the standard for a directed verdict is Your Honor, look at the evidence in light most favorable to the non-moving party, obviously the state, and that, in other words, that a directed verdict would only be appropriate if there is no conflict in the evidence for counts 1 through 4, and the state would contend that there has been more than enough evidence provided to counter that there is definitely conflicts in the evidence, and that the directed verdict should be denied, and that the case as to counts 1 through 4 at this time should be placed into the hands of the jury to decide the defendant's guilt or not guilt.
Okay. So my understanding is that if there is any evidence upon which a guilty verdict might reasonably be supported, then a criminal defendant is not entitled to a directed verdict of acquittal. Put differently, I need to ask if the evidence that exists now, the record that's been made through the state's case in chief, if it is sufficient to authorize a rational trier of fact to find the defendant's guilt beyond a reasonable doubt, if I view the evidence in the light most favorable to the state. So if there are conflicts, I resolve those conflicts in favor of the state's contention that this was an intentional homicide. I'm not saying that's what the jury would do, but for this thought experiment, I need to assume that that's how the jury would break it down. They would resolve conflicts in favor of the state. And applying those standards, I do find that there is sufficient evidence for the case to proceed. Not quite to put it in the hands of the jury yet, but to see if the defense wants to present any evidence, which it's entitled to do, but under no obligation to do. That is my ruling now as to counts 1 through 4. We'll talk about 5 through 7 a little bit later. So my thought is we could bring the jurors back in, and I'll ask the defense defense to call their first witness, and you guys will now be the managers of schedules. You got 1 hour and 5 minutes to fill with witnesses, and if we get to a natural break point, it's pretty close to 5. Be flexible as usual, and we'll stop. But let's just see how it flows, and we'll plan accordingly. And the state has some idea of who's coming?
Yes.
Great, okay. There were some concerns raised this morning about this just in slides, materials that are pertinent to Mr. Culver testifying. He won't be testifying today. And Mr. Smith. So hopefully you guys have been talking, and maybe none of those folks are testifying today, in which case the late provision will be less late of that material by tomorrow.
Yes, I understand the witness this afternoon will be a witness who's traveled and will testify regarding Marcella.
Okay, that's a different Mr. Smith. No, McKenzie.
I mean, and if we get done with them before 5, Stan Smith is here. We'll see.
Okay. Well, let's start with any witness you want, but it sounds like it'll be that one. Anything else, Ms. Clark-Palmer, before we bring the jury in?
Mr. Carter, do we need to go with Mr. Davenport and his?
Yes.
Right, exposure to the case. Sure.
Perhaps a short hearing outside the presence of the jury.
Yeah, like Dr. Sellers.
That's correct.
Okay,
So should we bring him in?
please.
Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir. If you will, have a seat. For the purposes of the court's record, please state and spell your name.
Name's McKenzie Davenport. That's McKenzie. Davenport, Davenport.
Want me to proceed, Judge?
Sure.
Okay. No.
We're not for the defense case. I keep them in there, but they can send in questions. Mr. Harvey didn't tell you that again.
Mr. Davenport, you and I have talked on the phone before today, correct?
Correct.
Okay. And I talked to you about coming to testify as a witness in this case last week,
April 3rd,
April 3rd.
a week from today.
Okay. A week back from
A week
today.
back from today.
Okay. Prior to that, did you have any reason to believe that either the state or the defense would be calling you as a witness in this case?
No, I've not been contacted.
Okay. And where do you work?
Arcilla Mining and Land Company, LLC.
And do you work with Ted Smith?
Yes, ma'am, I do.
Who is Ted Smith?
Ted Smith is the president and CEO and also owner of Arcilla Mining and Land Company.
Okay. And you knew about this trial, that this trial was taking place, right?
Yes, ma'am.
Okay. And because you had provided some documents to, along with Mr. Smith, Mr. Ted Smith, you all had provided some documents to the district attorney's office, right?
That's correct.
Okay. Have you seen any of the trial testimony that's occurred in this case?
Yes, ma'am, I have.
And how were you able to see that?
Online, I believe it's either through WSB TV or AJC.com. So there's several different sources that are playing it online right now.
Can you tell us how much of the trial testimony you have seen?
Really the day that I followed, I believe there was a specific day about Texas financial interest, and that was the day that I tuned in, kind of, I guess, intently that day.
Okay. And was that when Mr. Dean Driscoll was testifying?
I believe so.
All right. And do you think that how much of his testimony do you think you watched?
Probably 50%.
Okay. And are there any other witnesses that you remember listening to their testimony?
I know Danny Joe was up on the stand,
Okay.
and I think I tuned into a little bit of her testimony, but other than that, I can't recall anybody else.
And your involvement with this case, what's your understanding of just sort of generally what you're going to be called to testify about?
I think my reason for being here today is to show Tex's financial interest in our Scylla mining land. Up until January of 17, he had a 10% ownership in our company, and to show the value in that, give a time frame for that, and then also speak to some of his mineral holdings. There was a letter that Mr. Ted Smith wrote in, I want to say November of 16, and that letter placed a value of Tex's interest in our Scylla and also his interest in his mineral holdings. So I assume I'll be speaking a little bit to that letter.
Okay. So fair to say you're going to be talking kind of about numbers?
Correct. I
And,
hope so. Yeah.
I forgot to ask what, or if I did, I can't remember. What do you do at Arcilla?
I'm the CFO, so it's Chief Financial Officer.
Okay. And through your job as CFO, did you have involvement in coordinating the sale or the purchase of Mr. McIver's shares in Arcilla Mining and Resources that occurred in January of 2017?
Yes. I reached out to an attorney. We utilized a firm in Macon to draft the documents, and I reached out to them and said that we were going to finish, or I guess acquire 10%, the 10% that Tex owned.
I'm going to pause things right here. If you think what Mr. Davenport's about to share relates to the exposure to Mr. Driscoll's testimony, he should keep going. But I didn't think there was a challenge writ large to what does Mr. Davenport have to do with this case. The relevance to me is pretty clear. I thought right now we were just exploring what was your exposure, when did it occur, was it he could have even been told not to watch it, and it sounds like you've established that.
So I'll just jump to, I think my last kind of question or questions is there anything about what you saw Mr. Driscoll testify to that has changed or impacted your sort of anticipated testimony today?
No, I don't think so.
Okay. I don't have any other questions.
Mr. Davenport, I have a couple questions, and then we'll see if anyone can take his questions. Place in chronological order when you first understood you might be called as a witness and you watching Dean Driscoll intently for 50% of his testimony. Which came first?
I was notified that I was going to be called as a witness on April 3rd.
Okay.
So I believe Mr. Driscoll had given his testimony prior to that.
When you say you were notified you testifying as a witness, that's the first time anyone had even intimated to you, you're going to need to come to Fulton County, swear to tell the truth, and talk about the kinds of things, numbers.
We had there's a different Adam. It was an Adam from the district attorney's office, come by our office the week prior, and he met with Mr. Ted. And Mr. Ted was giving information about certain transactions. I believe there's a register of Tex's disbursements. And Mr. Ted needed help explaining certain transactions, so he brought me in, and I explained certain transactions and said, this is when this was done, this is what it was likely done for. So in kind of offhand, as the detective was walking out, he made the inclination that, hey, you may be called to come up there. So, but there was no official communication. There was no, yes, you'll be here on this particular day. There was no anything like that, so.
And did that person, who it sounds like came from the state side of
Yes, sir.
things, say to you anything about, hey, because you might be called, just stay away from news about the case?
No, sir. There was no notification of that.
All right. And I understood your testimony to be that even though you watched intently a significant portion of Mr. Driscoll's testimony, it's not something that either hardens your opinion that, oh, you know, he's wrong, this must be right, or shaped it in any way. Just
No, sir.
paying attention to it.
Yes, sir.
Okay.
I had it in the background as I was working doing my regular job.
I'm hearing that's been going on.
Yeah.
Okay. Anyone from the state have questions for Mr. Davenport? Oh,
Other than, you said you watched 50% of Mr. Driscoll and then some of Danny Joe, is that all you can recall that you watched in the trial?
Yes, sir.
And what do you recall Mr. Dean Driscoll saying in the portions that you intently watched?
Well, he had a section on there's a letter that I was referring to that Mr. Ted had written. So I kind of keyed in when that letter came up during his testimony. And that's kind of the main takeaway was his analysis of that letter, or his understanding of that letter.
So is it fair to say that the parts of his testimony that you intently, I guess, zeroed in on were the parts that had to do with Arcilla Minor?
Yes, sir, you could say that.
And did you watch from the beginning to the conclusion of all the testimony that concerned anything about the company Arcilla that you work for?
No, sir, it was not 100%. So there may have been other sections, there probably were other sections where Arcilla was referenced, and I was not watching at that time.
No further questions.
okay. I'm going to allow Mr. Davenport to testify. You didn't do anything wrong, by the way. I don't want you to start, oh my God, what are you doing in Fulton County? You just needed to understand what type of exposure you had had to testimony, because witnesses, prospective witnesses aren't supposed to be exposed to the testimony that occurs before they testify.
Yes, sir.
Consciously or subconsciously, that can cause folks to shade their testimony one way or the other. But I will allow the state to cross-examine Mr. Davenport as to what he was exposed to through his perfectly appropriate viewing of Mr. Driscoll's testimony. Anything else you want to cover before we bring the jury in?
No, Your Honor.
Gentle reminder to both sides, your roles have shifted. I think it's going to be more of a transition for the defense, but no leading questions when you're doing direct exam. And we'll just see how all that plays out. And I know this is like having no jury in here. These crazy rules.
I said we don't need the witness. I'll just get up and say, this is what he's going to say, and then Mr. Abadi get up and say, no, this is what he's going to say, and it'll be a lot faster.
What stipulations are for. All right, let's bring the jury in, please.
Can you just say your name?
Yes, you stay put. You can stand for the jury.
Yes, sir.
That's a court exhibit, but it's eventually we're going to have to come up with numbers for them all. Some of them may go with the jury.
All rise for the jury. Our jurors are present in the county court, jury.
Thank you, Deputy Murphy. You all can be seated. Ladies and gentlemen, welcome back. We may have a slightly different feel in the courtroom because we have entered another phase. We've worked through many of the things that one works through at the conclusion of the state's case in chief. And Ms. Clark Palmer has relayed to me on behalf of the defense that they will be presenting some evidence, and we actually had to talk with this witness a little bit outside the presence, which is why he's already seated here. He's already been sworn in, he's under oath, and I will now turn things over to Ms. Clark Palmer for a direct examination of the witness.
Yes, and Your Honor, we had called McKenzie Davenport to testify. So Mr. Davenport, will you tell the jury where you work?
Yes, I work at Arcilla Mining and Land Company.
And what do you do there?
I'm the CFO, or Chief Financial Officer.
Okay. And where is Arcilla? Tell me the company name again.
It's Arcilla, Arcilla, Mining and Land Company.
Okay. And where is that company located?
It's in McIntyre, Georgia, which is in Wilkinson County, Georgia. It's about 30 minutes due east of Macon.
All right. And that's where you drove from today to be here?
That's correct.
How long have you been the CFO at Arcilla?
8 years.
Have you always been the chief financial officer there?
No, I've worked for 2 years with a site preparation construction company in West Point, Georgia, and then prior to that, I worked for Ernst & Young as an auditor.
Okay. So I'm going to come back to Arcilla, but I want to talk about your background and education that enables you to serve as the CFO. Where did you go to college?
Went to Auburn, and I've got my undergraduate there, and I got my master's of accountancy there.
And after you got your master's, did you take any exams or obtain any certifications?
I took my CPA designation, and after in earning the correct amount of hours through work, I was able to get a CPA designation. However, I have not maintained that license. It's not a requirement currently, so I've not kept up with my continuing education hours.
So you have a background in accounting, right?
Correct.
Okay. And now at Arcilla, what does Arcilla Mining and Resource?
Now, Arcilla Mining and Land Company.
And land.
So, and that's a designation because there is an Arcilla Resources.
Okay, we'll come back to that, but what does Arcilla Mining and Land do?
We mine kaolin.
Spell kaolin, please.
Kaolin. It's a white chalky mineral that's prevalent in middle Georgia. It's one of Georgia's largest exports. Right now it's utilized, traditionally it's utilized in paper. The white glossy finish is kaolin. Kaolin is utilized as a filler. It's also utilized in ceramics, toilets and bathtubs and sinks. It's utilized in a little bit in tires, tennis shoes, cosmetics. There's hundreds and thousands of different usages for kaolin, and they're continuing to come up with new ways to utilize it every day. Right now, Arcilla does not process it. We're simply a mining company, and we've also got a trucking entity as well. So we will mine and we will deliver kaolin to different processing plants throughout Georgia and Alabama, South Carolina, and North Florida.
And who is Ted Smith?
Ted Smith is the owner, CEO, and president of Arcilla Mining and Land Company.
And how long has Arcilla Mining and Land Company been in business, if you know?
Since 1991 is I believe, the official Secretary of State registration.
All right. And so you told us that Arcilla Mining and Land mines kaolin. Does that mean that Arcilla Mining and Land owns property?
In addition to mining kaolin, we also see ourselves as a company that acquires tracts of land, that acquires kaolin deposits. So we also have a portion of our company goes out and negotiates with landowners, negotiates with property owners in an attempt to acquire new tracts of kaolin that ultimately we will sell to a processing plant. So we've got a mixture of we almost consider ourselves a raw material supplier and a mining contractor.
So as a mining contractor, does that mean that Arcilla Mining and Land Company owns equipment that is used to mine?
Correct.
kaolin?
We've got There's a total of 240 employees between mining and trucking, and every of the 240 employees, 220 employees are on some type of equipment, whether that's a large excavator, a large off-road dump truck, a large dozer, a motor grader, and we've also got an entity called Arcilla Trucking Company that has on-road trucks, which are dump trucks and tractor trailers that will deliver the kaolin over the road to different processing plants. So we have a lot of equipment.
So you said it, but say it again. How many employees did you say Arcilla Mining and Land Company has, and the trucking company?
240.
All right. And the equipment that you told us about, is this equipment expensive equipment, and is it sort of specialized equipment, not the type of thing that you can go down to Home Depot or whatever?
No, this is, we've got a mixture. Our largest off-road truck is a 60-ton Caterpillar off-road truck. If we were able to buy them for about $750,000 a piece. We typically buy 2 at a time. You've got 349 excavators, which are around $400,000 a piece. You've got D6 and D7 style dozers. They're around, the D7's probably $380. The D6, you can find one for about $300. So on an average price standpoint, of the 240 employees that we have, 220 are in heavy equipment. Of the 220, 60 are on the trucking side, and then 160 on our mining side. So we probably have 160 pieces of heavy equipment that are ranging from $300,000 to $700,000 a piece. So it's a significant number. And then on the trucking entity side, we've got 60 on-road truck drivers, and if you want to buy a brand new truck today, every truck that we buy is for the most part brand new, but it's around $200,000. So per truck.
Okay. So fair to say that Arcilla is not some sort of just kind of mom and pop, a couple employee business?
That's fair to say. It's an expensive business.
Okay. And I asked you how long Arcilla Mining and Land Company had been in business. Do you know how long the Arcilla Trucking Company has been in business?
No, ma'am, I do not.
Has it been in business for as long as you've been the CFO?
It has been. So there was a prior entity called Arcilla Trucking, Inc., and then when I came on board, we reorganized to Arcilla Trucking Company, LLC. So I came on board in 2010. So prior to that, I'd say at least 5 years plus. So we're talking 13, maybe 15 plus years.
All right. So now, can you tell the jury, as CFO of Arcilla Mining and Land Company, what do you do?
I manage all accounting aspects. I've got a staff underneath me. We handle...
How large is your staff?
4 to 5. So we're not large. We try to keep it small just to keep costs down. But payroll is handled in-house, accounts payable is handled in-house, receivables are handled in-house. So my job is to make sure the staff is completing all these daily tasks and then prepare monthly financials and present monthly financials for review to Mr. Ted.
Okay, so when you are talking about monthly financials, are you talking about things like, yeah, bless you, Doug. Are you talking about, sorry, let me start my question over. When we talk about monthly financials, are we talking about like how many contracts Arcilla has outstanding for mining?
That's right. From a monthly financial standpoint, the main interest are the profit and loss statement and income statement, and also a balance sheet. And then we're also constantly looking at how much tonnage we deliver to our customers. So we track that on a daily basis. And we've also got long outstanding contracts with our customers as well that plays a role in the value of our company. We've got certain contracts with customers that are 5 years. We've got certain contracts with customers that are 20 years.
So you're keeping an eye on how much money is coming in and how much,
Your Honor.
can rephrase.
Okay.
Profit and loss statement, did you say that was part of the monthly financials?
Yes, ma'am.
What is a profit and loss statement?
It shows money coming in, which is revenue, and then it shows expenses, which is effectively money going out. Our money coming in will be what a customer pays us to deliver Kaolin or to provide a service. Expense is our labor charges, fuel charges, repair charges for equipment, and then we also pay royalty charges for minerals that we may be buying from a property owner.
Well, so just, can you briefly explain that? What do you mean when you say paying royalties on minerals?
Right. When I spoke to the fact that we're a raw material provider, we enter into contracts with landowners to acquire minerals from their property. So these...
Is kaolin a mineral?
Yes, kaolin's a
Okay.
mineral, sorry.
All right.
So kaolin's a mineral, it's a white chalky mineral. But we will enter into contracts with landowners, and it's a mixture of, you can either buy a property fee simple, which is buy everything at one time and say, this is your land, and all the mineral rights are included with it, I'm gonna write you a check for this. Or I can enter into a mineral lease agreement, which allows me to go onto your property and mine minerals, and I will pay you a monthly check for the minerals, the kaolin, that I extract from your property. So when I say a royalty, we pay our landowners a royalty for the tonnage that we move from the property. If I'm on tract A and I sell 1,000 tons of kaolin from that tract, then I will pay the property owner 1,000 times whatever our royalty rate is for the minerals that we've extracted.
And do you know Tex McIver?
Yes, ma'am, I do.
How do you know him?
He was an owner of Arcilla Mining Land Company.
Have you met him in person?
Yes, ma'am, I have.
How, just to your kind of a general time frame, how long do you think you've known Tex McIver?
Probably since I came on board with Arcilla.
Okay. And you said he was an owner of Arcilla Mining and Land Company?
Yes, ma'am.
All right. So when you say owner, did he own the entire company, or what was his ownership?
His ownership was 10%. So when I came on board, at a time prior to that, he had a 50% ownership. But when I came on board, it was a 10% ownership.
When you came on board 8 years ago?
Correct, in 2010.
Okay. Well, I was going to ask you if you know how long he had been a partial owner of Arcilla Mining and Land Company.
No, ma'am, I do not.
All right. So his ownership, partial ownership of Arcilla Mining and Land Company, was that in his own personal name, the name of Tex McIver?
No, it was not. He had an entity called Arcilla Resources, Inc., that was the 10% owner of Arcilla Mining and Land Company.
So I'm going to show you one. Can you look at this and let me know if I have correctly written down the names of the 3 different Arcilla companies we've talked about?
This needs to be changed to Arcilla Trucking Company, LLC. Sorry.
Okay. The other 2 are correct?
I believe so.
All right, so I'm going to put this up on the overhead, and I've shown it to the state. I'm not. Okay. So just. The first company, Arcilla Mining and Land Company, LLC, that's the one that Ted Smith is the CEO, correct?
Correct, President and CEO.
Okay. You told us about Arcilla Trucking, LLC, and Arcilla Resources, Inc. that's the company through which Mr. McIver had a partial ownership in Arcilla Mining and Land Company.
That's correct.
All right.
Arcilla Resources, Inc. was the 10% owner of both Arcilla Mining Land Company and Arcilla Trucking Company.
Okay. So let me show you what's been introduced into evidence as State's Exhibit 148. Have you seen that letter before?
Yes, ma'am, I have.
All right. And have you been involved in providing documents to the district attorney's office in relation to this case?
Yes, ma'am.
Okay. And about when do you think that documents were provided to the district attorney's office?
I would say, trying to think back through my emails.
I don't need a date, but just can you
yeah.
give us maybe like a month?
I believe it was February or March, February probably,
Of this year?
of this year.
All right.
January this year, sorry.
Okay. So now let me publish 148, States 148, and ask you some questions about it.
Okay?
Well, and before we dive into the text of 148, does Mr. McIver have, outside of his partial ownership of Arcilla Mining and Land Company, does he have additional interests in property that you know about?
Your Honor, that's what you're saying.
It's not, I'm not asking for a conversation. It would be through his knowledge as his position of CFO of this company.
But how would he have that knowledge?
It's, my understanding is that it's part of the business dealings of Arcilla Mining and Land Company.
The business dealings exception to hearsay? Or it's just not hearsay?
It's not hearsay. I'm not going to be asking him about an out-of-court statement that I'm offering. For the truth of the matter, I'm asking him because it's going to explain language that is in this letter that is in evidence.
Okay, why don't you ask the question, now that I have that context, why don't you ask the question again, don't answer it yet, please.
Okay.
I'm ready.
All right. Are you aware of additional interests that Mr. McIver has in property related to Arcilla Mining and Land Company?
So don't answer that yet. Unless Mr. McIver told him that, I guess I'm not seeing how that's not hearsay. So why don't you ask other questions about the letter, and then I may better understand what you're trying to do.
Okay. So, all right, let's start with the letter. This letter is signed by Ted Smith. Who signed this letter?
Mr. Ted Smith signed this letter.
Okay, is that the same Ted Smith that you told us about, President and CEO of Arcilla
Yes, ma'am.
Mining and Land Company? And can you see this statement can you see where my finger's pointing?
Yes, ma'am.
The statement that says Arcilla mines and transports millions of tons of kaolin annually and regularly assesses the value of reserves and property. You see that, where that's written in this letter?
Yes, ma'am.
Is that the same thing that you were telling us about before, that is the business operation of Arcilla Mining and Land Company?
That's correct.
Okay. All right, so the next sentence in the third paragraph says, my evaluation of Mr. McIver's privately held current holdings include an EBITDA-based calculation for his minority shares and estimated mineral worth by inferred drilling on the 3 tracts that Mr. McIver has an interest in. You see that statement?
Yes, ma'am, I do.
Okay. What is inferred drilling?
Not familiar with the term inferred,
Okay,
but drilling,
okay,
we have a drill crew, and it's three guys in a pickup truck. And the pickup truck has a drill apparatus attached to the back. So when we go out to evaluate a tract of property, either a landowner contacts us, or we looking at a map, notice that there's a particular geographic function that's of interest to us, we will gain access to the property after asking permission, or after entering into an agreement with the landowner. We'll send a drill crew out there, and the drill crew will literally plot out on a map a series of drill holes, and they will take a drill and go down 5 feet and pull up dirt, go down 10 feet, pull up dirt, go down 20 and 30, 35 feet, and then hopefully at some point they will hit kaolin. That may be 35 feet down, that may be 50 feet down. But they will then extract the kaolin and then take a sample of it. It's called a core sample. They will pull up that core sample and note how many feet there were of that kaolin. So if it's from 40 feet down to 60 foot down, and then they'll note that there's a vein of 20-foot bed of kaolin at this point. So and from this drilling, we will plot out 100, 200 drill holes on a particular piece of property, and then through drilling, attempt to quantify the amount of kaolin on a particular piece of property. So that's when we're evaluating whether or not to acquire a piece of property, we will go out and we will drill and determine that this piece of property, we expect it to have 300,000 tons of kaolin. We expect it to have 500,000 tons of kaolin. We expect this property to have 2 million tons of kaolin. So that's our process of drilling. It's going out to the individual piece of property, setting a drill grid, and then going out and literally drilling into the earth and pulling up samples of either dirt or kaolin.
And you said that that's a way to estimate the value of that piece of property?
Correct. From that estimation, we will quantify or estimate the amount of tonnage that we expect there to be on that property. And the more tonnage, the better.
Since it's an estimate, it may be incorrect, right?
Correct.
It might be too low, right?
Correct.
Or maybe too high.
Correct.
Okay. So the second half of this statement in this letter says estimated mineral worth by inferred drilling on the 3 tracts that Mr. McIver has an interest in. What are the 3 tracts that Mr. McIver has an interest in?
And again, Your Honor, I'm going to object to hearsay.
Do you know the 3 tracks that he has an interest in?
I have been told of the 3,
Okay,
there's
that's
2
fine. You
tracts
already answered my question.
by Mr. Ted Smith.
Okay.
Are there tracts of land that that Mr. Smith has an interest in along that you know of because of your job as CFO?
There's one particular tract, and this is on property records. You could pull up Q Public in Twiggs County, and you will find a tract that Arcilla Resources owns.
Your Honor, I'm going to object again. This is just a backdoor way of getting in hearsay.
No, I'm trying to establish a legal foundation to get in evidence that is either not hearsay or subject to a hearsay exception.
Okay. But I appreciate what you're doing, and I encourage you to keep doing that. But Mr. Davenport ought not to share with the jury what he thinks record that we don't have says in it. You're okay? Just keep answering the
Yeah.
question.
No.
Do you remember where you were in your answer?
Well, he was where he
yes.
stopped because he was telling us what was in some property records from Twiggs County, which we don't have here.
Okay. Well, without talking about what that document or what the Twiggs County shows, do you know that there are tracts of land that Mr. Smith has an interest in through your job as CFO of Arcilla Mining and Land?
I'm going to object again as to hearsay and relevance as to Mr. Smith owning tracts of land.
What's the relevance of Mr. Smith, his network, or what he owns?
No, I'm not asking about Mr. Smith's network, but I'm going to link it up to, if I can, to properties that Mr. Smith and Mr. McIver both have an interest in.
Okay. through.
question?
Sure,
Okay.
please do. I'm not ignoring you,
Yeah.
I'm thinking through what you're trying to do also. Let's try a different question.
Okay. Mr. Davenport, you've seen this letter, State's Exhibit 148. You've seen this before today, correct?
Yes, ma'am.
Okay. The letter is dated December 5th, 2016. Do you see that?
Yes, ma'am.
Okay. Did you see this letter back in December of 2016?
Yes, ma'am.
Okay. And how is it that you came to see this letter back in December of 2016?
Mr. Ted drafted it. Then I typically will review his correspondence for grammar and for punctuation and all that other stuff. My review came before it was sent out was for grammatical purposes, punctuation purposes.
Okay. So you saw this letter before it was sent out? Is that what you just said?
Yes, ma'am.
Okay. And the letter talks about the calculation for Mr. McIver's minority shares, right?
Yes, ma'am.
Okay. So the calculation of his minority shares, is that a calculation that you are familiar with?
Yes, ma'am.
Okay. How is it that you are familiar with that calculation?
That calculation was done because Arcilla ultimately bought out his 10% minority share interest in January of 17.
Okay. And so how did you calculate the value of his minority shares?
I'm going to object as to hearsay, because the letter and the calculation, or the letter says the calculation was done by Mr. Chet Smith.
Well, the letter may say that, but Mr. Davenport has said he played a role in it. That question's fine. We may get to a point where you're bumping into an issue, but why don't you repeat the question, and Mr. Davenport can answer it.
How was the calculation for Mr. McIver's minority shares, the value of his minority shares done?
We looked at our inhibited calculation.
Okay, so what's that word?
Sorry. Earnings before interest, taxes, depreciation, amortization. It's a way to quickly and easily put a value on a company. So it's a kind of a shorthand valuation. So you typically utilize that, and then you will apply a multiplier. Depending upon the industry, that multiplier can range from a 3-year multiplier up to a 10 to 12-year multiplier. So, but it's a way to value companies as a whole.
And is the value based on the kind of profit and loss of the company?
It's the profit and loss with the exception of depreciation, taxes, and interest.
Okay.
So it's earnings before
Okay.
depreciation, taxes, and interest.
All right. And did Arcilla Mining and Land Company ultimately buy Mr. McIver's minority shares of the company?
Yes, ma'am.
And when did that happen?
That happened in January of 17.
All right. And how would you characterize Arcilla Mining and Land Company's performance in the year 2016?
It was a struggle for us that year. So we had up until the end of 14, we had done extremely well. We had had continual revenue growth of 25 to 30% a year for about a 5-year stretch. And then in 2015, our primary customer ended up closing some of its plants. So our tonnage delivered from that customer, our revenue fell. Probably our revenue in 15 was around 60% of what it was from 14. So we experienced a significant reduction in revenue from 14 to 15 and ultimately 16. 16 almost mirrored 15 in terms of a bad year or a struggling year.
Has it gotten better?
It's gotten better.
Okay.
Yes, ma'am.
So does that mean if you had done the calculation of Mr. McIver's minority shares back in 2014, would they have been worth more because the business was doing better?
Yes, ma'am.
So ultimately, in January of 2017, how much did Arcilla Mining and Land Company purchase Mr. McIver's minority shares for? And if you need to refresh your recollection by looking at a document, just let us know what you're going to look at.
Let me grab, I have the purchase agreement right here. It was in January of 17. The purchase amount was for $700,000.
Okay. That was for the 10%, the 10% of his minority shares?
Yes, ma'am.
Was the $700,000, was that amount negotiated with Mr. McIver?
Yes, ma'am. That was directly between Mr. Ted and Mr. McIver.
Okay. Do you see the line here? Well, so let me ask this question. The $700,000, to make sure I'm correct, is only for Mr. McIver's minority shares of Arcilla Mining and Land Company. Is that right?
Correct.
Okay. Does that $700,000 include estimated mineral worth by inferred drilling on the 3 tracts that Mr. McIver has an interest in?
No, ma'am.
Okay. And then do you see the next line, the estimation of all current holdings lay somewhere between $1,500,000 and $2,500,000?
Yes, ma'am.
Okay. Why is that number, $1,500,000 and $2,500,000, why is that greater than the $700,000 you just told us about?
I don't know if that's wrong, what you said.
Why don't you ask him how he know that? I don't know whether it's going to be hearsay or not. It could be, it might not be.
Do you know the answer to my question? Without telling me what the answer is, but do you know the answer to my question of why it says 1.5 million and 2.5 million in the letter, but you just told us 700,000?
Yes,
Okay. How do you know the answer to that?
because the valuation is based upon his minority shares and
Well, just,
You're on that for a second.
is it based on information you have in your job as CFO, or is it based on something that Mr. Smith told you?
we have not mined off Mr. McIver's tracks.
Objection, Your Honor. Hearsay.
Overruled.
We have not mined off Mr. McIver's tracks during my time as CFO, but I've looked at the financial records, and there has been prior mining from Mr. McIver's tracks. I believe we have written him royalty checks in the past. I believe those ended.
You say there was prior mining on Mr. McIver's tracks, mining by Arcilla.
Yes, sir.
You're not looking at some other company's records. Your own
No, sir.
records reflect your own company cut royalty checks to Mr. McIver for his company.
To Arcilla Resources, yes, sir.
You can keep going.
So that finished up in 2004 was the last royalty check written to Arcilla Resources. So from that standpoint, I know that he at that point had a tract that we were mining from.
Okay. Well, you said a tract. Do you know from looking at financial records or records of Arcilla Mining and Land Company if he has additional tracks.
I can see that.
Hearsay.
Well, he said he can't say, he can't answer that.
Okay. Okay, so you just know about the one tract.
Yes, ma'am.
All right. Where is that tract of land located?
There is a tract of land that's located in Twiggs County that is, it's actually between two tracts that we're currently mining right now. So when one of the tracts that we're currently mining, we're removing about 400,000 tons a year from that particular tract. The tract on the adjacent west side that we're currently mining is we're removing around 100,000 tons a year from that particular tract.
You said currently mining.
Correct.
So does that mean you currently, Arcilla Mining and Land Company currently has a contract with Mr. McIver's company?
Not on that particular tract as of this moment. We're not currently mining it, and we do not have a current contract on that tract. But on the tract immediately adjacent to the west and immediately adjacent to the north, we have contractual agreements, and we're currently mining and pulling tonnage off those tracts and writing royalty checks on those tracts.
Okay.
Sure.
I want to make sure I understand what you just told me and make sure I didn't misunderstand it or that the jury didn't misunderstand it. There is a tract that is being currently mined? Yes? Or no?
Not owned by Arcilla Resources.
Okay. Okay, so who owns the tracts that you were telling us, the one to the, I think you said there was one to the west and one to the north?
The one to the west is owned by an LLC. It's called Fin and Feather LLC.
Okay.
I believe a guy in Sandersville owns that tract. The one to the north is actually owned by T.S. Smith Development,
Okay.
which is a holding company for Mr. Ted, and it's also owned by a timber business called Gay Wood Timber Company.
Okay, all right. All right, so now I'm with you. So you're saying the tract that was owned or is owned by Arcilla Resources was the one that had paid royalty checks before?
Correct, up until 2004.
Got it. Okay. All right, thank you. Those are my questions.
Mr. Abate, it is about 10 minutes to 5. How long do you forecast your crops to be?
That's probably around 40 minutes.
Okay. Well, we won't be able to finish that before we need to let the jurors head home. Is there a chunk you get started with, so we use the next 10 minutes, or how do you see it structured?
I think my preference would be to,
Just start fresh in the morning?
yes, Your Honor.
Okay. So, Mr. Davenport, we do our level best to get you up on the stand and out of here, because my understanding is your commute makes ours seem like it's a small town commute. You get to enjoy a small town commute, though, 364 out of 365.
That's right.
But we're going to need to break for the day. The jurors are putting in a long day, and we'd have to stop at 5 anyway, and we wouldn't get through what remains. So I apologize, we couldn't get everything in. I don't know if Arcilla has a nice hotel room for you at the Ritz.
I've got a soccer game at 6, so 6:30.
Okay.
I'll see if I can hurry and get back.
Okay, well, I hope you're able to do that. We'll need to have you back here at 9 in the morning. Between now and then, please don't talk with folks about your testimony. If Mr. Ted asks you how it went, the answer is, sir, I'll tell you about it when I'm all done.
Yes, sir. Yes, sir.
Appreciate your time, and we'll see you in the morning.
Yes, sir.
Jurors, waiting for Mr. Davenport to go. You can stay right there. But if you need to go get this soccer game, go. Okay. We're going to break for the day. We actually, the attorneys and I and Mr. McIver have some more things that we're going to work through that we deferred from this last break. But we'll get busy with that now and finish it up this evening so that we ought to be able to start up as close to 9 as we can all be here. And hopefully Mr. Davenport will be back. We'll have the cross-examination, any redirect, and then any questions from you all. And then we'll see what else the defense may have for you all. Okay? Reminder, even though the state is rested, same restrictions. When you go home tonight, as much as you might want to research the case, watch the news about the case, don't do that yet. Please enjoy other things in life.
All rise for the jurors.
And if you're eating off of fine china, just think there could be, say, kale in it.
Kale.
Kale, there could be kale in it.
Please be seated.
Did you drive one of those big dump trucks up here?
An
People
old pickup
get out
truck.
of your way.
Old pickup truck.
Okay, all right, the drill in the back?
No, no drill. No,
Okay,
that's
all right.
dangerous.
Thanks for your time.
Thank you.
Mr. Harvey, Mr. Samuel pretty much short-circuited your motion for a directed verdict. Do you want to short-circuit his motion for a directed verdict? Just rest on the pleadings?
No, you've got some.
Okay, all right. What I'd like to do now is hear from Mr. Samuel, or whomever, I think it would be Mr. Samuel. He read like a Mr. Samuel thing. About the motion for directed verdict on counts 5, 6, and 7. The motion that was timely made. In fact, the written motion was submitted before the state rested. Crystal ball that the state would actually rest in this case. The state did rest. It was timely made, and we agreed to defer the actual discussion of the motion until we sent the jury home for the day. With that, you're already at the podium. Talk to me and the state about why I ought to grant a directed verdict as to the 3 counts about influencing witnesses. I've read this, so you don't need to do chapter and verse, and I'm actually more interested in hearing what the state has to say in response as to counts 5 and 6. But you should feel free to argue all 3.
I'm curious what their response is to count 7, if they're even going to make a response to count 7. Maybe you don't even want to hear about 7 because it's such a weak count. But
Well, okay, we're ranking them differently, but you should talk to me about whatever you want.
Well, I'd like to structure the argument somewhat like I did the brief, although, you've got our presentation. Now you know exactly what our argument is. I don't have anything to add based on what happened today from what we put in writing to you. You're right, we filed it yesterday. I don't think Mr. Dickerson's testimony really changes anything on 5, 6, or 7. And obviously I drafted it before Mr. Crane testified. I've been drafting it for 2 or 3 weeks we've been working on it, so we were anticipating based on the testimony. So we can't cite transcript pages, but we tried the best we could last night before filing to make sure if there was anything that Mr. Crane said that was inconsistent. But you understand what we're doing. We're trying to give you a heads up so that we weren't walking in here today citing cases to you for the first time, and
Sure.
the prosecution would have been hearing for the first time.
Well, let me give you my
Sure.
processing of it, because that may shape and limit what you want to share in response. As to count 5, your perspective is that Mr. McIver didn't, well, let me take a step back. The conduct at issue in each of the counts, per the statute, needs to be efforts Mr. McIver made to mislead the witness who's referenced in there, not to get that witness to mislead the police.
Exactly.
It is, I am misleading you. It's not I'm threatening you or bribing you. I am misleading you in an effort to cause you to somehow
Mislead.
law enforcement, DA's office, or judge.
Correct. So it's
Not
a double misleading.
The secondary one is, I don't know if it's necessarily misleading, is maybe it's withhold. Don't
Hint.
tell them this, tell them something that's not correct.
Exactly.
But the part that I think is important here, and it applies to at least one, if not two of the counts, is what has the state shown that Mr. McIver did in an effort to mislead Danny Joe Carter or Bill Crane? Now, the third count, arguably, there's Mr. Carter as well, but the way the state has charged it is the ultimate goal was to mislead Danny Joe Carter into doing X.
That's exactly right.
So, as to count 5, the part that I need to hear from the state on is what was it that Mr. McIver did that was misleading to Danny Joe Carter? I think the goal was to get her to basically stay away from the police, don't talk to them about what you know. And so the end game is consistent with the statute. The means, I don't see it being there, but I'll be educated by the state. Count 6, I don't see how Mr. McIver did anything, misleading or not, to get Mr. Crane to not talk to, mislead, or do something with police, DA's office, or a judge. And I appreciate the state's perspective, which I suspect I'll hear in a minute, that, hey, if you're talking to the media, you're talking to everyone. And I appreciate your language, shame on the Fulton County District Attorney's Office, ... But I'll need to hear from the state as to how, what we've now heard in great detail from Mr. Crane, those efforts by Mr. McIver and others to get Mr. Crane to take back from the media what he told the media, how is that consistent with what the statute prohibits? Question to you, how is it not misleading on Mr. McIver's part, not count 7, to say, oh my gosh, I'm going to go to jail, bad things are going to happen to me if you don't do these things, Danny Joe Carter? When in fact, I'm not aware, and you can help me understand, if there was, Mr. McIver knew that unless Danny Joe Carter got quiet or went to this press conference / deposition / whatever Mr. Maples was going to do at the meeting, he would in fact be jailed. How was he not, how could that not be construed, if we're looking at this in the light most favorable to the state, as misleading Ms. Carter as to the impending doom for Mr. McIver?
Well, it's odd because count 7 seemed to me the easiest.
Well, here we go. It is odd.
Yeah, it is odd. In fact, I actually thought this DA was going to stand up and say, let's just do 5 and 6, because based on the evidence we heard from Mr. Cardwell and from Mr. Carter, the only thing, you got to only look at the voicemail message. There's nothing else except the voicemail message, correct? And the voicemail message says, I need to talk to Danny Joe. He never says, don't let her talk. In fact, everybody who testified, meaning Cardwell, Danny Joe, and Tom Carter, was that he wanted her to talk. He wanted her to go to the deposition / press conference, whatever was going to Maples' office. Don't be quiet. Don't not talk. Go and talk. Because, according to all of them, these 3 witnesses who testified, she was providing exculpatory evidence. And her testimony was, and Tom Carter's testimony was, that the reason they didn't want to go was not because they didn't want to tell a lie. Well, there's not too many negatives in that sentence. The reason they didn't want to go was they were sick of the press. They were sick of being hounded by the press, number 1. Number 2, he had a lawyer. How come we don't have a lawyer? It was some weird thing like that. And then they got a lawyer, Mr.
Lee Davis.
Lee Davis. So I wasn't quite sure what that was all about, but there was some concern. But never was that phone call interpreted by anybody, and there's nothing else other than what the words on the phone call are, to say, don't go talk to the police. Stop talking to the police. It was the exact opposite. It was, and again, the interpretation comes from all the witnesses who say, we hid out from the limousine. Remember, they were sending a limousine to go pick her up. There was, nobody said, and if I missed something because I drove out and what have you, you'll let me know. Nobody said that she was told you need to stick with the story. Nobody said that she was told you need to pretend you weren't in the car. Nobody said you need to go to the press or the press conference or the deposition, I don't know what they're talking about, the deposition, or give a sworn statement that is untrue. On the contrary, we desperately need you out there in the public because I'm getting vilified. That was the interpretation given by Cardwell and Tom and Danny Joe, that he wanted me to go talk to Maples and then to the public. And it's really kind of supported by Crane, who says, although it's not that clear, this was my suggestion, get everybody out there talking. This is October 4th when this phone call was made. So how is that, how is a witness being misled? Where is it misleading to implore someone to go speak? If my lawyer or my co-defendant or the lawyer for a co-defendant says, Don, go out there and make your statement.
So I guess the way I was understanding, and we'll hear from the state in a second, their characterization of this, and it doesn't seem to be inconsistent with the same set of facts, is that Ms. Carter felt her testimony, increasing pressure. They're even going to send a limo to pick me up. I feel so much pressure, not just from the media, but from the McIver team, that I'm going to hide out somewhere because I don't want to do this thing, because they're trying to lock me in and text, you know the truth. You don't need me to come in and give some statement and lock me in, you know the truth. And so then there's this phone call to Tom Carter saying, and I need the transcript, maybe someone will get it for me. Yeah. But what I'm remembering is Danny's going to send me to jail. She needs to come do this thing.
Right, and what is this thing? Is to go speak. And the indictment says that they're imploring her to cease communicating. That's not what happened at this trial.
Okay, well, I need to marry it up with the language of the indictment, because that may be why you find 7 to be so.
Page 3, I've set forth the indictment word for word. I hope I haven't done anything improper. You can use the actual ones you want. It says, by leaving a voicemail statement with Patricia Diane Carter's husband, Thomas Carter, wherein the defendant implied in said voicemail statement that Patricia Carter ceased communicating her recollections of facts and circumstances of the death to law enforcement officers. It had nothing to do with law enforcement officers. It had nothing to do with ceasing communication. It was the precise 180-degree opposite. It was, go talk to these people. I need the public to be better informed, because that's again, this is the testimony. This is not the words of the statement, but it's the testimony of everybody who heard it and interpreted it and understood what the message being conveyed was. They're asking you to draw inference from what this was based on zero. We're asking you to draw an inference on what was said in that message by the testimony of Tom Carter, whatever Cardwell's first name is, I apologize, and David Jovers.
Now, I have the transcript now. Danny is about to send me to prison. Y'all have no idea the problem this is causing.
Right.
Okay.
This is being made as the limo is being sent, and she's not there. Right?
Okay.
So, A, where is the misleading?
I'm connecting now.
Okay.
So
It's the easiest one, right? It's the easiest one.
Crane may be easier, but I'm connecting now that I have the transcript of the recording in front of me, and then right next to it, count 7.
And then right next to it, the statute. That's the only 3 things you need.
Next to the building block.
Anytime.
Okay.
It's so simple on that count, I think, because you don't have anything misleading, you don't have what the indictment alleges, and you don't have any effort to hinder. Everything's missing in that count.
Okay, well, I'm disagreeing with you on the misleading part, but I'm now better understanding your contention about the others. Danny is about to send me to prison. I don't know.
The interpretation was, by the witnesses, he wanted public, what's the opposite of vilification? He wanted public support. That's not misleading her. That's like me yelling at my lawyer. Go out in the press and stand up for me. I paid you all this money. Go up and stand up for me. Right?
I'm hearing your words.
Where's the misleading? What is the lie? If it's a lie. How is Danny Joe misled by being told, I need you to go speak on my behalf? Unless there's something about speaking that she doesn't understand.
Okay. Got it.
So that's count seven. And
Yeah.
I have trouble not understanding everything you said on 5, 6, and 7. You're exactly right. They have to show misleading. They have to show that the witness is misled, not that the effort is made to mislead the police, the DA. I almost think perhaps I should just sit and wait. You can give me enough rebuttal time.
You will.
Because I don't know what they're going to say. And you know what I'm going to say.
Let's see what they have to say, and you will have the right to rebut.
Can the state request a short break, as you just received Mr. Samuel's brief last night, just so I can organize my thoughts as well as the case law to attempt to rebut his lengthy and characterization of the state's indictment?
I said it last night. Usually you don't get anything.
I give you 5 minutes, but we're after 5. I don't want to keep the court board too late, so I may not leave the bench, but you're free to confer for a little bit, and then I look forward to hearing from you. Hear from the state now in response to the defense's motion for directed verdict on counts 5 through 7, the influencing witnesses counts in the indictment. And in focusing on this, what I'd like you to do as best as you can, Mr. Abate, is show me how you think the evidence allows the counts as they are pled to go forward, given that we're limited to the misleading conduct toward another person, i.e. Ms. Carter or Mr. Crane, and not misleading conduct towards law enforcement.
Yes, Judge, thank you.
You bet.
And I would just want to start with, obviously you heard and read the standard that Mr. Samuel has, I guess, interpreted that the case law says, but there are other cases in other circuits outside of the Second Circuit, which were the majority, I believe, of the cases that decided in his brief, in which say that the way that the statute, the federal statute that tracks the Georgia statute, is to be applied. It kind of says that the authority is split in the sense that there are circuits that have interpreted the statute to mean that it, not necessarily that the defendant or, in any case, requires he or she to have misled the witness, but that the misleading conduct that he is engaged in with that witness, the end result is to mislead the law enforcement agency or whatever is, I guess, articulated in the count of the indictment for whichever jurisdiction it's being applied in. And the cases that I'm referring to, Your Honor, is United States v. Wesley, which is 748 F2D 962. It's the Fifth Circuit case.
Can you give us that again?
Yes, it is 748 F2D 962. And then, Your Honor, it's also cited from a Ninth Circuit case, which is the United States v. Boradallo, which is Bordallo, and that is 857 F2D 519. And again, that's a Ninth Circuit case. And in both of those cases, what the holdings are, what the courts there articulate, is that there are these two split authorities, or split ways to apply the statute, which one of the ways in which they're applying is that the misleading conduct isn't towards the actual witness, but it's for the witness to then use the misleading conduct by the defendant to then articulate that to the prosecuting agency, whether it be law enforcement, the DA's office, or another type of law enforcement agency, a judge, or a official proceeding.
Well, but isn't that, I read Mr. Samuel's motion to actually say there's two pieces to the misleading. the accused is misleading the witness, and that causes the witness to mislead law enforcement. And I respectfully disagree with him on that. I don't think that you have to have that second piece of misleading. You mislead, I will go to prison for sure if you keep talking to the police. I'm misleading you if I actually know I won't go to prison for sure. My goal isn't to get you to go tell the police that you weren't even in the car when the shooting happened. I just want you to stop talking to the police. You just stop. I think that that would be an example of influencing witnesses consistent with the statutory language. I don't think you need to have that second misleading piece. That could be what you get them to do. You'd be withholding from law enforcement the truth because you're giving them false information. But well, I don't know if that changes your analysis. I'm hearing you say that if I read these two cases, they may say, actually, the accused doesn't have to mislead this intermediary. The accused has to have as a goal, I'm going to mislead the police. And so the accused could say something he believes to be true to the witness, that the witness believes to be true, that causes the witness to go mislead law enforcement. I will read those cases with interest. I don't think that's what the statute criminalizes, but I could be wrong. And if I find the Fifth or the Ninth Circuit reasoning to be compelling, then I'll have to factor that in.
Yes, Judge, and that's, you summarized what I was trying to articulate or was articulating to Your Honor to a T, I would say. And I would say what those circuits, the way they have analyzed and interpreted the statute would be that there has to be some sort of misleading conduct. The witness that they're telling it to doesn't have to be misled. The end goal is that his misleading conduct, the lie that he's asking the witness to tell law enforcement, is the actual misleading, the engagement in the misleading conduct. And I say that as those cases, they hold that urging and advising a witness to testify falsely violates the statute, which in federal courts is section 1512. Without indicating whether it even needs to address the intimidation or the actual misleading conduct, in the sense that the misleading conduct is towards, or the person who, the witness, who they're making the statement to, has to actually be misled. And I say that as Your Honor just said, you gave the example of what the defendant knows to be true, what the witness knows to be true. So if you reverse that, so in this case, you have Mr. McIver making a statement to Miss Danny Jo Carter, which is the subject of count 5, where he is at the hospital telling her, basically, you were never in the car. If anyone asks you, you tell them you were never in the car. That would include police, nurses, anyone asks you, your family friend that found out about it and you came up here. And that would be the state's articulation of the misleading conduct that's being directed at Danny Jo, and it's being directed at Miss Danny Jo Carter, because that's what the defendant is asking, or in a sense telling her to tell law enforcement, which would include the police, the district attorney's office, and even non-law enforcement, members of the hospital staff. And I would go even further to say that she then, because of his actions that night and ongoing throughout that first week, where he's trying to take her statement, where he's urging her to, where he's actually trying to write it down, and she takes a sheet of paper back saying, these are my memories, not your memories. You need to focus on yours, not mine, as well as his urging through himself and also through his defense counsel that she needs to make the statement publicly. And the state will contend that the reason he's doing that is because he wants to hear what she's going to say so he can craft his story or his statement around hers. And that would be the reason, I guess those are the compounding reasons as to why his statement is misleading, or the conduct is misleading that he's engaged in, and his end result is towards the prosecuting agencies. So that would be my interpretation of the statute based on the cases that I read, and I apologize, I have extras that I can provide the court.
Citations are all I need. What's your understanding about whether attempt has to be charged, or if that's always a lesser included, or how that works?
It would be my understanding that the attempt is always included in that. And I can get you, I read it earlier, and I can get you the case law or the,
I'm sure I can find it. I just was curious if you had on the top of your head in connection, for example, with count 5, an attempt to mislead Danny Joe Carter. Hey, you know what? You weren't here. You need to tell people you weren't in the car and just get away from the situation. It proved to be unfruitful. She was not misled by that effort to get her to tell police something, to withhold information from the police, to withhold the truth from the police. I think the second half of the statute is present in count 5, and where Mr. Samuel gets traction is, well, it wasn't really misleading. Mr. McIver knew what he was saying. That's the less important part. Ms. Carter was not misled by Mr. McIver saying, you know, the Jedi mind trick. You weren't there. You weren't in the car. Just tell folks you weren't in the car. You know what the truth was, and I'm not going to do something like that. So it might be construed as an attempt, but.
and I wouldn't necessarily disagree with the court, but my reading of the cases, and I would stand on the fact that they interpreted it as the urging Ms. Danny Jo Carter to lie to law enforcement satisfies that first problem, the engaging in misleading conduct. So that would be the state's position as to counts 5, that is the misleading conduct that Mr. McIver is engaging in, and the purpose for doing that is, or the intent for doing that is to prevent her from telling law enforcement agencies what actually happened in the vehicle.
Okay.
And then as to count 6 with Mr. Bill or William Crane.
Yes.
Who I would agree with, Your Honors. Had a lot to say. But as to that count, my interpretation as to the first part, or the problem that we've talked about here, or as the engagement in the misleading conduct, would be the same as I've expressed it for count 5, and that the misleading conduct that Mr. McIver was engaged in was again trying to, or attempt to get Mr. Crane to retract or lie about what Mr. McIver had told him. And I would analyze this, or add further, that Mr. Crane wasn't in the vehicle. He doesn't know what happened. What he is basing, I guess, what he's communicating to Ms. Hobbs as well as Mr. Schneider is based solely on what the defendant told him. And I will bring to the court's attention that during Mr. Crane's testimony, this happened over a long period of time, it happened multiple times, and each time it was, well, I don't think I said that, or maybe your memory is wrong. So, and then I think it evolves into, no, I didn't say that, you're wrong, and you need to follow the sword. So I believe that would satisfy the analysis that Your Honor, Mr. Samuels was discussing. I guess that's different than the way the state interprets how the statute should be analyzed.
Let's say I go along with your assessment that there were all sorts of steps that the defendant took to mislead Mr. Crane. I didn't say that. You're misremembering, et cetera, et cetera. And we get past the debate, and I appreciate Mr. Samuel's perspective, which is what Mr. Crane wasn't ever misled. He was steadfast in saying, no, it is what you said, and I was the conduit through which you said those things. But set that aside. How do you get past the second prong of the defense attack on this, which is Crane is a media guy, and he was talking to the media, and it was all about, please, Mr. Crane, this would be defendants talking, go back to the media and tell them that you were mistaken, that you got it wrong. Retract it, not to Detective Smith, not to Paul Howard, not to some magistrate judge or any judge, but all media. How do you get past that, especially when the focus we've now heard from Mr. Crane's testimony wasn't, I think about the bump as a problem because that's not what I told the police. It was solely the Black Lives Matters, which in terms of the investigative analysis, is not particularly germane.
Well, I will start with, I guess, addressing the fact that the media isn't a part of, I guess, law enforcement, who is,
They'd be surprised to learn it if
You say they are,
I said are not a part of law enforcement. But if you want me to say are, then that's the argument, right? But no, they are not part of law enforcement. But I believe in a prior hearing, Mr. Rucker eloquently and very well explained to Your Honor that yes, the media is not law enforcement, but law enforcement. All these publications are local, and they go out through actually the state, they're statewide, and with the internet, not only are they statewide, but they're nationwide.
Globally.
Well, yes, global. So I guess that's why Mr. Crane is so famous. But what I would say to Your Honor is that not only, yes, he's expressing to the media, but I think it was articulated in Mr. Crane's testimony through direct and cross that one of the newspapers is the Fulton County Daily Report, which is a newspaper that's targeted at attorneys. Well, prosecutors are attorneys, and yes, we can read Mr. Harvey. So, with that publication being targeted at attorneys, which the district attorneys are full of them, I would say that that is a clear reason, or how that his retraction of the statement and then a reprinting would then reach the district attorney's office and would change very much, or could very much and possibly change the way that we approach our independent investigation of the case, as well as the same analysis would go for law enforcement. Law enforcement also can read, and many of the law enforcement read newspapers. And the AJC is a very well-known newspaper that majority of people locally read, as well as the fact that law enforcement, because they work closely with attorneys, have access to the Fulton Daily Report. And if a prosecutor was to read the article that retracted it, it's very likely that we would then have a conversation with the members of the Atlanta Police Department, because there are times where coordination is done, or at least communication about cases is done, because that's the process. The APD or any law enforcement agency, they start the initial investigation and start the case going, and then it comes to the district attorney's office. So whether the police agency or the district attorney likes it, we have to coordinate in some way or work together in some way in order for justice to be done. So
let's talk about count 7.
And then as to count 7, I think Your Honor has correctly analyzed it based on what you had said earlier. And I would say the misleading conduct that Mr. McIver is engaged in, like the indictment expresses, is the voicemail that he leaves on Mr. Tom Carter's voicemail, asking him to talk to Danny Joe, telling both of them that what she is doing is nuclear, and it's going to send him to prison. And that's the misleading conduct, in the sense that he's telling her whatever you're doing, whether it be hiring a lawyer, making statements, talking to the police, is going to send him to prison, which would be the misleading conduct. Because if she's telling I guess, one, she doesn't know that, and if he's telling her that, it very maybe false. And therefore, because of that, the misleading because of that statement and the misleading nature of it, it may very well cease what she's doing. The end goal, which is to get her to either fire her lawyer or to stop talking or to talk to him so they can get their story straight, doesn't have to actually occur for the account to be valid. The end goal that Mr. McIver, his intent, which is to get her to stop talking to whoever or to not have an attorney, doesn't actually have to occur in order for the account to be valid.
So I hear you that the efforts don't have to be successful.
Right.
But what was at play at the time Mr. McIver left this voicemail with Tommy Lee, as he put it, was actually an effort to get Ms. Carter to talk, not to law enforcement, but to Mr. Maples. This deposition, but it was somehow going to be a public deposition an odd event. I think we can all agree on that. But that was, from all the testimony from the record, what prompted the voicemail was not Ms. Carter talking to law enforcement, but it was her reluctance to sit down for this public deposition. And while I appreciate your perspective, and it may be 100% correct, that the goal was to get the stories aligned, and it's kind of hard to do that if you don't have someone locked in. Oh, now I videotaped you, can't really change from this story. Now you've done that, we can dovetail things a little bit better. That isn't, how is that an effort to get Ms. Carter to withhold information from law enforcement? Wow, that's a long note. And you've got about 12 Post-its up there too. But let's focus on my question first, and then you can review all that. It was an effort to get Ms. Carter to talk, not to law enforcement, to Mr. Maples, etc. More relevantly, it was not an effort to get her to not talk to law enforcement. It really didn't have anything to do with law enforcement directly. And I appreciate you putting together this sort of causal linkage that, you know, the net effect would be a less free flow of information in theory to law enforcement or your office or a judge because they're working to align their stories. I don't know that that's prohibited, aligning stories, but it also isn't telling Ms. Carter not to talk to law enforcement or to tell them something other than the truth.
Right. I guess my response to your question would be that the intent for the misleading conduct and the intent of that conduct done by Mr. McIver was, I wouldn't say it was to get her not to talk to law enforcement. It was to get her to publicly make a statement, therefore, which again, if it's publicly being said, it's going to reach law enforcement. Then if her statement changes in any way, then you've got inconsistent statements from Ms. Carter, therefore affecting the investigation made by the Atlanta Police Department as well as the District Attorney's Office. And the attempt was to get her not only, it said what you're doing is innocent but nuclear, which is, and we know it was on the same day she was supposed to make a statement, so what she was doing that was innocent but was nuclear was not making a public statement and not talking to Mr. Maples, therefore crafting the statement that she should make publicly, because she did make one statement to the police, but if you make a second statement publicly that's inconsistent with what you told the police, then you have altered the investigation immensely, not only by the Atlanta Police Department, but by the District Attorney's Office. Furthermore, I would say that Mr. McIver had no idea at that point still what Danny Jo had said to the police. So again, by talking to Mr. Maples, he gets an idea of what she said, and then they can craft her statement for her to make publicly to fix any problems or mistakes that had caused the situation to be nuclear for Mr. McIver, and that was going to send him to prison. So that would be my take or analysis upon that.
Okay. Do you want to process any of those, or you have integrated the input from your colleagues?
I think the only thing that I didn't integrate, and Ms. Conway makes a great point, was that during Mr.
Enough of that.
She does? You're not the only smart one in the room, man. She made the point that Mr. Crane made on the stand was that Mr. McIver said to him that what he said and what, I guess...
What who said?
That what Mr. Crane said to Hobbs and Schneider, and that through the series of conversations he had with Mr. McIver had with Mr. Crane, that evolved to, you know, please take this back, I didn't say this, you're the one that's mistaken. He, in addition to that, said, this is hurting my case big time. And well, it's hurting this case. The case is being investigated and prosecuted by law enforcement and members of the District Attorney's Office. So I think that further compounds the effect that his statement, had he retracted it, in reaching members of law enforcement. So, and I would request, Your Honor, that I could have time this evening to draft a brief in response to some of Mr. Samuel's arguments, and maybe I can organize it a little bit more eloquently, Your Honor, to make sure that you understand, I guess, the way the state is analyzing and the way the state sees that the cases that I've quoted has interpreted the federal statute 1512.
Okay, I'll get back to you on that in a second. Mr. Samuel, I told you you could have the final word in this setting, which I will let you do in just a sec. You're free to address any or all of it. I am most interested in my notion of count 5 as an attempted influencing witness.
If the statute allows it, there's a 1643. 1643 specifically says all indictments for substantive offense include.
That was my recollection.
Yeah, well, you were right.
Not that statute, but that concept.
Right. Who cares about the statute? But I'm a little confused by why you think it's an attempt to mislead. He tells her lie. Right? You accept the testimony. He tells her lie. Right? There were 2 cops standing behind you. He looked over my shoulder. He was thinking about the cops. We didn't get into race, at least with those witnesses. He says, I don't trust these people. Okay? Meaning law enforcement. So just tell them you weren't here. And tell them that whatever, you just drove, just completely ridiculousness, right? And Mr. Harvey said that was stupid, right? Because obviously you were there. You drove in, surveillance, you're getting out of the car, the bullet goes through the seat. Who was the driver? Some Martian who disappeared? I mean, it made no sense. But he clearly was telling her to lie. There was nothing misleading about it. It was just a blatant lie. So I don't understand what the attempt, how was it an attempt if it wasn't a full-fledged effort to urge to lie? It was suborning perjury had there been an official proceeding, 1610-93A. It would have been, if you were in federal court, a 1503 violation. You remember that. And, there's all kinds of violations involved. Making a false statement to police, right? They could have charged that. They didn't. Instead, they charged that there was, an attempt to mislead a witness. And I don't understand how it was even an attempt to mislead a witness. Right? The testimony was, tell a lie. Maybe the attempt was to get her to do the final thing. But what he did was a completed offense. But not this one.
But not this one.
Well, that's exactly right. Because there's 2 elements to this offense, as you've articulated quite well. One is you mislead a witness, A. B, you're trying to get the witness to, I say, mislead, hinder, obstruct, do something with the transcript, as you put it the other day. Right? Well, he did whatever he was going to do. It was completed. There was nothing more to be done from his end vis-a-vis the witness. So I don't understand why there's an attempt that would even be at play there. So that's count 5. And if I'm missing something, I'd be glad to.
No. I just need to work through it. I'm somewhere between you and Mr. Abate on count 5. You don't need to talk about count 6 unless you want to. I don't need more input on 6 at this point.
Okay. Can I say shame on the prosecutor again?
You did. It's in writing. It's up right.
I got to warn Mr. Harper seriously. If they're saying lying to the press, right? Lying to the press is a crime. Then there's a lot of us who are in trouble. There's a lot of us who are in trouble. Because if they read everything we say in the Fulton County Daily Report, and we say,
We don't.
well, if they don't, then it's not a crime. Because they're saying they read it. They read what is said. Anyway, you get it.
I do the protestations of innocence that are de rigueur in any prosecution of any profile.
And not just advocacy, but statements of fact. Right? My client was in Anchorage. Right? If it turns out that that's not true, it's a crime. They're saying, if I tell the Fulton County Daily Report, my client's got an alibi. Anyways, you get it.
I got it.
Why waste time on 6, right? On count 7, I listened to what he says, and it's just kind of, it could have been this, it could have been that. Maybe he was thinking about this. Maybe he was thinking they should get their story straight. What are we talking about? It's supposed to be proof beyond a reasonable doubt that he told her, he misled her. There's nothing misleading about that statement. To get her not to communicate with the police. None of that. is borne out by the evidence. And all they can say in response is, well, maybe it was a code, it sounds like. Maybe what he was trying to say was, I don't want you to talk to the police yet without first coming and talk to Mr. Maples, because when he talks to Mr. Maples, maybe none of that was in the evidence.
Well, I also, that's not what I heard Mr. Abate saying. Your stronger argument on this one is the audience that Mr. McIver was concerned about, which is, why aren't you going to talk to my lawyer, and if there is a member of the press there, why aren't you coming to do that? And that's where I believe he's influencing her, trying to influence her to go. I think the stretch is on the state side to say, well, but you know, we can get these concatenations that say that aligns their stories, and then that'll be public, and that's, I think, akin to some of the issues with count 6. But I think some of what Mr. McIver said in the voicemail could, viewed in the light most favorable to the state, be deemed misleading. But you've got two arguments with count 7, and the one I'm really grabbing onto right now is what was it about? And it wasn't about, you're going to send me to prison if you talk to the police. You're going to send me to prison if you don't talk to the police. It's, you're going to send me to prison because you're not getting in the limo to sit down with my lawyer and some reporter. And I appreciate that you could follow that chain of causation to ultimately, that's a bad development for an investigation, for a prosecution, etc. But I don't think that's what the statute reaches.
And we know that she's already talked to the police, so whatever. We know that. So I've looked at these two cases. I don't understand why Mr. Abate would cite United States versus Wesley if he read. Unless I'm
I've been listening to you guys, so I haven't read Wesley yet.
I don't ask why you, I would love you to read it. I wish I'd cited it. It is, and I've just been sitting here staring at it, waiting to get to the punchline where it says what he says it says. Wesley,
Maybe it's the reversal of Wesley.
well, maybe I missed it. I just looked at 748 F. 2nd 962. If it's been reversed and overruled or something. What Wesley says is, you'll remember the way the federal obstruction statutes are structured. You have 1503 is the original obstruction statute. Then in 1982, right when I started practicing law, they passed the Victim Witness Protection Act, the WPA. That had all the 1512 protecting witnesses. You can't kill a witness. You can't coerce a witness. You can't threaten a witness. Right? You got Supreme Court cases, Fowler, and all these cases talking about victimizing witnesses. That's what 1512 is about. That's what 1610-93 was passed to mimic, to mirror, word for word, not even a comma's difference. And when it comes to misleading, it says misleading, right? It doesn't say urging to lie. It's very clear about that. What Wesley deals with is what happens if you urge someone to lie. And what the defendant was saying is that's no longer a crime at all, because 1512 eliminated that as a crime. And what I can't remember what circuit Wesley is. It's on my
I think it's 5th.
Yeah, but the 5th circuit said Judge Rubin, that's right, it was Alvin Rubin. What he said was, wait a second, just because 1512 no longer makes it a crime to urge someone to lie, you can still be prosecuted under 1503, which of course is true. That's what I've been saying here today. It's not a 1512 violation. It's not a 1610-93 violation. It's a different crime. It's urging someone to lie. Suborning perjury, if you have an official proceeding, obstruction of justice, which in the federal system would be 1503. That's what Wesley says. Now, I've looked at it quickly, sitting here. I haven't studied it carefully, but that's what it says. The second, that's the 748 F. 2nd 962 case. It is directly supported. I wish I'd cited it. I'm embarrassed that I didn't cite it. I don't understand the Bardello case, 857 F. 2nd 519. It is confusing, to say the least. Just reading that.
That's often code for you don't like its outcome.
It might be. I'm not sure, because first of all, it talks about intimidating witnesses. So if it's an intimidation case, what are we dealing with? But it's got some language about misleading in there that I just can't quite follow. And then it says the way the witness was misled was into thinking that bribing the governor of Guam was a good thing to do because it would help the poor people. I'm completely lost at that point. But it sounds
It's a great case, though.
Yeah,
The facts of the case.
It sounds like it, but I'm not going to say I understand the case yet. It's a lengthy opinion, unlike Wesley, which was 2 pages that I could see.
Okay, maybe you were missing the key pages.
Maybe it might be Westlaw, you all use Westlaw or Lexis? Oh, see, that's the problem.
Lexis has the full edition.
Yeah. So anyways, I don't get it. I don't understand how they could possibly say the 161093 says what it doesn't say. I mean, the statute's clear. If there's been some interpretation of the Ninth Circuit in some weird case, whoever follows the Ninth Circuit in Georgia, this would be the first case in history.
If anywhere, it would be Fulton County.
Right. So, we have, we believe in our motion to dismiss for 5, 6, and 7. We believe that the court should rule tomorrow morning before we start putting up witnesses. Grant the motion for directed verdict on all 3 counts. I'd like to adopt, if I could, I suppose, in the record, each and every argument I've made in the brief, as opposed to what we've been answering here. I don't want there to be any waiver of a particular issue. And if I get a brief from the state at some point tonight, as long as I get it by 3 in the morning, I will be prepared to respond tomorrow. When we commit, they'll do me the favor of emailing it and not putting it on Odyssey, where I would never find this.
Well, they may want to do both, but they should email you a courtesy copy. And Ms. Lyon. So here's a question then. Your next hassle of witnesses, do they have anything to do with counts 5, 6, and 7? Do any of your witnesses have anything to do with 5, 6, and 7, or are they all 1 through 4? And at least the witnesses for tomorrow. And I'm asking only because I'm inclined to let Mr. Abate organize his thoughts and put something on paper, just so that we get a full presentation of both sides. You are asking for extraordinary relief. And as long as witnesses through lunch tomorrow will be dealing with counts 1 through 4, I'm going to grant the request. But if you have a special witness who is coming in tomorrow morning just to talk about Bill Crane or something, then
Hard to imagine.
okay, Bill Crane. All right, let's do this then. I'm going to take this under advisement. Mr. Abate, if you or your team wants to put something in writing and get it to Ms. Lyon and Mr. Samuel before you go to bed tonight, then that'll be timely. And you don't need to file anything in response if you don't want to, you don't need to. I leave that up to you. I'm not looking for a response, I'm just looking for point, counterpoint. And I may not even ask for any more oral argument. I'll process that. And I may well be in a position tomorrow at 9 to get something on the record. Otherwise, we'll do it by lunchtime tomorrow. So at least you all have some guidance. Should I grant a directed verdict as to 1 or more of these 3 counts, my thought is I don't say anything to the jury until we get to the jury charges and say, for your consideration now are only these counts and not all the counts. But you guys should be thinking about how you want me to relay to the jury. I guess it would have to be before closing arguments. It would have to be before closing arguments. But just think about how that message would get delivered if there is going to be such a message. Anything else from the state after this long day? Ms. Griffin, I haven't heard from you much at all today. How are you doing?
I'm fine.
Appreciate you being here.
Well, nothing else from the state.
All right.
I'll make one follow-up to Your Honor, just for you to think about this evening. Is the plain language of our statute, the Georgia statute, is you have to engage in misleading conduct towards the witness. It doesn't say that the witness has to be misled. It just says you have to do misleading conduct, which is lying to someone and trying to get them to lie, is misleading conduct, and then the second part of the statute.
I hear you. That's why I'm wrestling in the way that we've talked about it. All right. You guys talk amongst yourselves in a minute. Anything from the defense before we break? All right. 9 o'clock tomorrow morning. Thank you, everyone. Thank you, Ms. Weaver.